Hey, today's question is, are patents international? It's a great question. This is about whether the US patent or whether a different country needs a patent, how you're going to secure your rights around the world. And the first answer is, well, each country has their own set of patent laws. So here in the United States, we have the United States patent law. In Canada, they have their own set of laws and rules, and every other country around the world. The cool thing is that there has been a treaty, and it's been around for almost 100 years on the patent utility side called the Patent Cooperation Treaty. And the PCT, for short, what it does is that all these countries, most every single country you've ever heard of, have agreed to this Paris Agreement, which is what it was originally called at the treaty. And what it does, it allows one country, your home country that you designate, to act on behalf of the whole world. And so the PCT lets the US examiner and their search be reflected and be honored, if you will, by all the other countries around the world. And so say you file here in the US, you indicate you want to file the PCT, Patent Cooperation Treaty Act, and then that examiner now will do that search on behalf of all the countries. So now if you decide to file in, say, the European Union, Australia, or Canada, the European Union examiner, or at the specific country, let's say, Germany, they will look at the search results that the US examiner provided as the basis of their examination. Now, they will still have their own special rules sometimes with regard to patent drawings, the format, and sometimes, of course, the translation. If it's in a foreign language, it must be translated into German if that's how the German examiners want to review it. So it is important to work with a U.S. attorney so we can get you in touch with a German attorney that can help you navigate some of the nuances with respect to German law. But the other benefit to the Patent Cooperation Treaty and having an international perspective is that you likely want to time out your filings to be advantageous. You don't want to waste money. So usually it's best to wait until you find out whether the U.S. examiner gives it a thumbs up, gives it a green light, or if they reject it. So you want to make sure you know where you're at in terms of the prosecution. Maybe eventually get it to the place where it's ready for granted here in the U.S. That's when a good time to file it overseas. U.S. examiners are known around the world as some of the most rigorous. And so usually if the U.S. examiners have approved it and granted the patent, it will likely get granted in other countries. And it's just a matter of paying the investment of the fees to get it filed and all the prosecution that requires in those separate countries. There is other things to talk about with regard to the design patent applications. International design patent applications follow a different protocol called the Hague Agreement for industrial designs. But very similarly, all the other countries will recognize the one source of search that your designation country will take on. You still have to be a novel, a novel design, while the one U.S. examiner will act on behalf of the whole world in that sense. And so the Hague Agreement is what's used instead of the PCT on the design side. All right, well, that's it for today. Have a good day, everybody. Go big, go bold.